workshop. This is a presentation of the Asian American Bar Association of New York's Anti-Asian Violence Task Force. My name is Young Chen. I am the Executive Director of the Asian American Bar Association of New York, AABANY. And we're very pleased to be able to present this very important program at this time of increased violence against our community. And to kick us off, I'd like to introduce our moderator, Eugene Kim, who is Vice Chair of our Pro Bono and Community Service Committee. And he is also an attorney with the Legal Aid Society and is a criminal defense attorney. Eugene.
Okay, I'll take it away. Thanks, Young. So today's presentation is going to be broadcasted with the live translation in Mandarin and Cantonese. You can turn on these translations by clicking on the globe icon below in the Zoom and selecting the language of your choice. Please also participate in this discussion. We'll be having a Q&A at the end. So if you click the Q&A button at the bottom, you can type in your question and I will sort through the questions for live answers from our panelists at the end of our presentation. If someone else has already listed your question, give it a thumbs up. So today we're here to discuss self-defense and the defense of others. And I'll be your moderator tonight. Tonight, we also have two amazing speakers. We have Professor Elaine M. Chu of St. John's University School of Law and Assistant District Attorney Joe Kim, the Chief of the Hate Crimes Unit and Deputy Chief of the County Court Trial Bureau at the Nassau County District Attorney's Office. Thank you both for being here with us today. So back in March, many of us witnessed the video of the elderly woman in San Francisco who physically fought back her attacker and in turn caused him physical injury. Because of violent incidents like this one that she faced and so many others, we've all been thinking about what if something like this happens to me? Many Americans, and in particular Asian Americans, are thinking about how they will respond if they are victims of an assault or witness an assault as it relates to the hate crime epidemic in our city and in this country. Many are wondering about whether they would respond to such an attack with violence and what, if any, legal implications are there with regards to both civil and criminal law. Professor Chu will be discussing the civil aspects of the law, while Joe will be discussing criminal law. Now, Joe, can you explain how self-defense works in criminal cases?
Thanks, Eugene. Self-defense is also known as justification within the criminal law. And self-defense is a legal defense when someone is accused of some type of assault. In other words, when someone assaults another person, that person can show that he was justified and then be found not guilty of that assault. The most common assault crime in New York is assault in the third degree. And that happens when a person with the intent to cause physical injury to another person causes an injury to that person or to a third party.
So how much injury has to occur for it to be an assault?
That's a great question, Eugene. So physical injury is defined in the statute as an impairment of physical condition or substantial pain. The pain must be substantial and not minor. Courts have said that petty slaps, shoves, kicks, and the like delivered out of hostility, meanness, and similar motives are not within that definition. So it's got to be a bit more than just slaps. In order to be found guilty of assault, you must also have intended to cause the physical injury to that person. And intent is defined as a conscious objective or purpose. In other words, the actions must have been done on purpose.
Okay, so Joe, where does self-defense come into play here?
Well, if you purposefully cause injury to another person, you would be guilty of assault in the third degree unless you are justified. And a person has justification to use non-deadly physical force when and to the extent that he or she reasonably believes it to be necessary to defend himself, herself, or someone else from what he or she reasonably believes to be the use or imminent use of physical force by such individual. Now that's directly from the statute. So first, the person defending themselves, the defendant in this case, must have actually believed that the other person was using or was about to use physical force against them or someone else. And second, the defendant's own use of physical force must be necessary to defend him, herself, or someone else. And third, a reasonable person in the defendant's position, knowing what the defendant knew and being in the same circumstances, should have reached those same beliefs.
Okay, then Joe, so what do you mean when you say a reasonable person?
Okay, so even if you truly believe that the other person was using or was about to use physical force against you or against someone else, a reasonable person or a normal person would also have had to have come to the same conclusion. So if you really believed you or someone else was about to be hit, but a normal person, another person with normal senses would not have reached that same conclusion, then you would not be justified in using force.
Okay, well, how much force can you use in self-defense of yourself or others?
Okay, so that's a good point. Once the threat of physical injury has passed, you must stop using physical force. Continued physical force or excessive physical force would not be justified.
Okay, then so can you describe other instances where you would not be justified?
Okay, so under self-defense law, there's this concept called the initial aggressor. And if you were the initial aggressor, you can't be justified. An initial aggressor is the person who first attacks or threatens to attack. In other words, the first person to use or threaten to use imminent physical force. Even if you're not the first to throw a punch, you could be the initial aggressor if you threatened the use of force with words.
Okay, but if the other person calls you a racial slur or otherwise provokes you, would you be considered the initial aggressor then?
Most likely, yes. So it's important to remember that unless the other person in words or actions is threatening to use imminent physical force, you can't respond with violence. If someone calls you a name or tries to provoke you with racist language, that usually doesn't rise to the level of a threat of violence. And if you threaten them with violence in response to their provocation and a fight ensues, you would not be justified, and therefore self-defense wouldn't apply to that situation.
Okay, so I see like the threat must be imminent, right? So what if they threaten to do something later? Like if they tell you and threaten you, I'm coming back to get you.
That's a good point. So it does have to be an imminent use of force. So in that case, if you were to respond with force, you would not be justified. The threat has to be imminent, not sometime in the future.
Okay, well, are there other situations where you would not be justified as well?
Yes. So you would not be justified if you provoked the other person by doing something with the intent to cause physical injury to that person. You would also not be justified if the physical force involved was the product of a combat by agreement. So the concept of combat by agreement is important to understand here because that occurs when both sides agree to fight. So for example, if before a physical altercation happens, one or both parties say something along the lines of, you want to fight, or come on, let's go. If it can be shown that both sides have essentially agreed to a fight, then you are no longer justified. So that's really important factor if they're trying to provoke you and now you want to fight and you respond to that, you could actually be entering into a combat by agreement, and therefore you would not be justified, and you could theoretically be arrested and convicted of assault.
Okay, so are the laws for self-defense different if you, let's say, use a weapon to protect yourself, or no?
Okay, so under our law, there are two kinds of weapons that can be illegal. And one is the per se illegal weapons. That's what we call them, per se, that you can't possess under any circumstances. And the second category are weapons that become illegal when you use them illegally. There's also a broad prohibition on the possession of firearms and certain rifles and shotguns. That's way beyond the scope of today's conversation. So we'll just be discussing the non-firearm weapons. Per se weapons are weapons that are listed in a statute, and it includes a wide array of weapons, but they're pretty specific and have definitions. I'm going to do a short slideshow so I can demonstrate some of these for you.
And then if anyone has any questions anytime, feel free to drop a question in the bottom in the Q&A box.
Francis, can you enable the share screen, please? Thank you. All right, so we'll start at the beginning. Okay, so moving back, the first prohibited weapon is what we're looking at here, which is metal knuckles. They're metal that go over the knuckles, and they're supposed to strengthen your punch when you hit them. The second weapon that's listed, that's kind of a common per se weapon that you would avoid, is a switchblade. No one can own a switchblade in New York. Switchblades open when you press a button and they'll spring out on you. The next one we have here is a cane sword. Not a particularly common weapon, but it would be a sword that's concealed within a cane. Electric dart guns and electric stun guns are actually prohibited weapons. You cannot possess them in New York. And collapsible batons. They're actually called a billy under our law. They're listed in the statute and defined as anything that can open. They may be cylindrical and they can be concealed in a sheath. Strangely, shuriken or Chinese stars, I think they're called in the penal law, they're also prohibited. So you can't own, throwing stars. The next prohibited weapon we have is a handheld slingshot. Those are also prohibited weapons. You cannot possess these in New York State legally. And then actually I've included this last item, nunchucks, because nunchucks actually used to be illegal, but they were declared, their prohibition was declared to be unconstitutional by a federal court. So now you actually can possess, these nunchucks. So here we go. All right. So those are the per se weapons that can't be possessed under any circumstances in New York. You cannot use these or possess them for self-defense purposes or any other purpose, that you just can't have them in New York. Now, the second broad category is called dangerous instruments, and they can't be possessed with the intent to use the same unlawfully against another. And a dangerous instrument is any instrument, article, or substance which, under the circumstances in which it is used, attempted to be used, or threatened to be used, is readily capable of causing death or other serious physical injury. Some common self-defense items include pepper spray, and really anything that can potentially cause serious physical injury is something that would be a dangerous instrument. But again, those are only illegal if they're possessed and used unlawfully. And therefore, if you were not justified in using that weapon, then that would also be potentially criminal.
Okay, thanks for clarifying what would constitute a dangerous weapon, Joe. So the next question is, when are you justified to use deadly physical force against another person?
Okay, so a person can use deadly physical force upon another person when, and to the extent that they reasonably believe it's necessary to defend themselves or someone else from what they reasonably believe to be the use or imminent use of deadly physical force by that other person. And deadly physical force means physical force which, under the circumstances in which it is used, is readily capable of causing death or other serious physical injury. As you can see, it doesn't talk about whether you intended to cause death, simply whether or not the force that was used could cause death or other serious physical injury.
So if the other person has used physical force against you, can you respond with deadly physical force?
No. If the other person is simply using physical force, you cannot respond with deadly physical force. Meaning, if they are not using deadly physical force, you can't respond with the use of a weapon or something that would be considered to be deadly physical force.
Okay, so when would someone be able to use pepper spray, for example? You mentioned earlier that it would be considered a weapon if not justified.
That's a good point. So pepper spray or mace, different kinds of sprays, they will be considered a dangerous instrument. Therefore, it would fit within deadly physical force. And pepper spray may qualify when you use it. So you need to be using it to protect yourself from deadly physical force. Some factors that might come into play include the relative size of the person who's attacking you. So for example, if you're a small person, a small woman, for example, and the other person is a large adult male, it's entirely possible that you would be reasonable in using deadly physical force of pepper spray to protect yourself from the other individual who may be considered to be using deadly physical force, even though they don't have a weapon. The use of that level of force, though, it must be necessary. The question of what is necessary is a difficult question, but if a reasonable person would not have reached the same conclusion that it was necessary, then you may not be justified. Remember, it's not just what you believe, but what other reasonable people would think under the same circumstances.
Okay, so what about those scenarios where even with necessity, you would not be justified using deadly physical force, like the initial aggressor scenario you posed earlier?
Okay, so a lot of the exceptions to justification that I mentioned before still apply to the use of deadly physical force. Again, you would not be justified if you were the initial aggressor of using deadly physical force. You may be the first to strike the blow, and you may not be considered the initial aggressor so long as you reasonably believe that deadly physical force was about to be used on yourself or someone else. If someone threatens you using non-deadly physical force, you cannot use deadly physical force on them, since you would be considered the initial aggressor to use deadly physical force and therefore not be justified.
Okay, so you mentioned that deadly force can only be used if necessary. So does a person have a duty to flee then?
For the most part, yes. You would not be justified in using deadly physical force if you knew that you could, with complete safety to yourself and others, avoid the necessity of using deadly physical force by retreating or running away. The only time you don't have a duty to retreat is if you're in your own home and are not the initial aggressor. You also would not be justified if you, with the intent to cause physical injury to the other person, provoke them to use deadly physical force. Again, you won't be justified if you enter into a combat by agreement as well.
Okay, thank you, Joe. Now, let's turn to the question of civil liability. So in addition to the criminal laws, there may be civil implications when you use violence to defend yourself or others. Professor Chu, what are the basic differences between getting into trouble with the criminal laws and getting into trouble with the civil laws?
Thanks, Eugene. As you said at the beginning, there is definitely a difference between the criminal laws and the civil laws. So a civil lawsuit is really different in two important ways from a criminal prosecution. First, the civil lawsuits, what they would mean would be that another individual would be suing you and not the government, not the prosecutors, not the police. Now, that individual, it could be the person who was originally attacking you, or it could even be the person that you were helping to defend. And as I'll detail in just a moment, bringing a civil lawsuit does require some resources and effort from the plaintiff, from this person suing you. The second difference from a criminal prosecution is that the consequences that are sought in these civil lawsuits, the consequences are damages. In other words, money. These individuals would be suing you in order to try and recover money for the harms that they believe you have caused to them. The types of lawsuits in New York State that would potentially be brought in these kind of contexts are called tort lawsuits. And they are often, again, being brought by individuals who pay their attorneys through what we call a contingency basis. Contingency basis is different. It's not an hourly charge. Contingency basis in these tort lawsuits, they mean that attorneys would only get paid if they were successful in recovering a money judgment for their clients. And so this practice of a contingency payment system means that tort attorneys are usually very selective about which individuals they would take on as clients, which individuals they would help to start a civil lawsuit. And typically what they're looking to do is to work on behalf of clients who would have very strong civil claims against you and a real likelihood of a money judgment. And they usually will decline or say no to potential clients who have very weak claims and very low probabilities of winning in court.
Okay, so I guess the question that gets posed a lot is, what is a strong civil claim and what would constitute a very weak civil claim?
Yeah, so that's a really good question, because that would help you to kind of understand what's the probability of you getting sued by someone else. So the most likely tort claims, again, in this context that a person might sue you for, they are called assault and battery claims. And of course, this is a little confusing because Joe just did an excellent job of reviewing what these crimes are of assault, but there are also these civil torts known as assault and battery, and they have their own distinct definitions. So I'll just review them quickly here. A person is liable for civil assault when they intend to cause a harmful or offensive conduct with another person, or they intend to put that person in imminent apprehension or fear of such a contact, and that other person is put into that fear, is put into that imminent apprehension. A civil tort of battery requires actual contact, actual touching, and it's defined as intentional, wrongful, offensive physical contact with another person without that person's consent. And so you could see how in this context, talking about hate crimes and hate incidents, if we're thinking about civil lawsuits, it's likely to be an assault and battery lawsuit against you. So which ones are the strong claims? Which one would be the weak claims? That depends a lot on what you could say in your own defense. What's important to understand in these civil lawsuits is that you can successfully avoid a judgment of money damages by raising the same justification defenses that Joe just covered: self-defense and defense of others. So in other words, the defenses in these civil lawsuits, they actually track and follow the same criminal laws on self-defense and defense of others that he just laid out. So a strong civil claim against you as a bystander who used violence, let's say, to defend another person, would be one where you had a very weak self-defense or defense of other argument. So for instance, if you pulled out and started, shooting a gun at someone who merely shoved another person, that would be a situation where, yes, a tort attorney would be really interested in bringing a strong civil claim against you. A weak claim against you as a bystander would be where there was, let's say, obvious evidence of racial hostility from the person who's now trying to sue you, Another example would be if there were witnesses or videos that really go against their version of the story and really go with your version of the facts. Or another example of a weak claim against you would be if you stayed within the bounds of reasonable person justification laws, the way Joe just explained. So in those situations, while the other person may want to sue you civilly, they might have a really hard time finding a tort lawyer to do so. So to conclude, in both the civil and the criminal laws, the standards and concepts about using violence only when necessary and about stopping the use of violence when no longer necessary are just incredibly important defenses to avoiding any kinds of legal consequences. I turn things back to Eugene.
Okay. So what are some practical takeaways based on these legal lessons?
Thanks, Eugene. So this is really important. So I want everyone to listen up. If you use justified physical force, you still need to understand how criminal investigations work, especially at a crime scene, and how you can protect yourself. When the police arrive at a scene, they will see the aftermath of a violent act between at least two individuals. They're going to have to sort out what happened. Even if you were completely justified in your actions, and all of the law that I spoke about are different ways that you can, not be justified. But let's say that you're completely justified. They still have to sort out what happened. And the police at this point will need to listen to both you as well as other witnesses and the other person who at this point could be injured, and try to determine what happened. The result of the violence will likely be someone or both of you are injured. The officers are going to have to decide who's getting arrested. And the stories that are going to be told by the two of you are going to be different and opposite. So if there's no corroboration of your version of what happened, it's possible, even likely, that both you and the other person are both going to be arrested. And if you are both arrested, you will both likely be prosecuted and need to work with an attorney to assert that you were justified. Although justified, you will be processed in the same manner as the other individual and need to defend yourself in court.
Okay, so then what should someone do if they're being attacked or witness someone else being attacked?
So first and foremost, you should call 911. Get the professionals there. Remember, your calls are being recorded. Your statements to the operator are your first line of documenting the threat of physical violence towards you. If you can, repeat exactly the words that the other person used to threaten you, and tell the operator what's going on. Secondly, you need to, I would suggest documenting the violence if it is safe to do so. Don't participate if you don't have to, if it's not necessary. And what I mean by that is taking video. Use your cell phones, take video, audio recording, whatever's necessary, and do it at a safe distance and avoid physical conflict. Remember, I want to reiterate that the use of vulgar, racist, or other provocative language alone may not constitute a threat of imminent physical violence, and therefore your response to it could put you in legal jeopardy, and you would not be justified. So as another point, we talked about combat by agreement. Don't agree to fight someone. If you do, you're no longer justified. And if you're facing violence, flee. That is one of the obligations under our law, is that use of self-defense has to be necessary. And there is an obligation to flee before using deadly physical force. Try to remember the exact words used by the other party if you don't have it recorded. But again, when faced with two different versions of the story, the police officer has no basis to say one version is correct and one version isn't. So it's really important that if you can, you record these things. The next point I would bring up is you can't use weapons or other deadly physical force if the threat you're facing is not deadly in nature. So you can't bring a knife to a fist fight. Also, don't carry per se weapons. The Teenage Mutant Ninja Turtles, every single one of them is committing a crime when they walk around New York. You can be arrested just for having them. If there are bystander witnesses, get their information. Don't rely on, say, the police to necessarily be able to hold people around. You yourself as a bystander, doing the right thing is documenting the crime that you see, but also giving your information to the police for follow-up. Because oftentimes that's going to be the difference between a he said, she said, is what did the other witnesses who were uninterested have to say. Also, be aware of any surveillance cameras near where this incident is occurring. Again, don't rely on the police necessarily to get that or to write down that that exists. You need to point it out to them. You need to make sure it ends up on the police report so that it can be followed up on. There's surveillance cameras all over the place. And, you know, when you're fleeing, it's good to flee to a place that has cameras. If you're using necessary force, do not continue to use force after the physical threat has passed. So once the physical threat is over, if you're still, you know, pummeling him, that's a problem. So use the necessary physical force to prevent anything further from happening.
Okay, thank you, Joe. And thank you, Professor Chu. So before we open up the floor for questions, and you know, if you do have questions, please type in your question at the bottom. We've gotten a few that we'll be answering shortly. We want to recognize and thank our interpreters for their generous talents this evening. Kwok, our Cantonese interpreter, and Ye, our Mandarin interpreter, thank you so much for your help with this workshop. So now let's get to our first question for this evening. The first question we have is, what prompted AABANY to hold this webinar? Have these questions come up in the community recently? And I believe Young will be answering this one.
Yes, so we thank the audience for that question. And it gives me a chance to talk a little bit about AABANY as well as the task force. So AABANY has been around since 1989, and we represent the interests of Asian American and Pacific Islander attorneys and others in the legal profession and industry in New York City and New York State. We currently have about 1,500 members. We are one of the New York affiliates of a national organization called the National Asian Pacific American Bar Association, the AABA. And you may have heard about our report, our anti-Asian violence report that came out in February. And shortly after the report was released, AABANY formed this anti-Asian violence task force. And it includes many of our prominent committees, including the Pro Bono Committee, the Prosecutors Committee, the Student Outreach Committee, Academic Committee, et cetera. And the purpose of the task force was to see what we can do as a bar association that has a mission to advance the interest of the Asian American and Pacific Islander community in New York, what we can do to move forward some of the proposals that we came up with in the report. And we decided that we could do it in three main ways. First is education and communication. Second is advocacy. And third is research. So we've been doing a lot of speaking engagements, and that's part of our education and communication prong in our task force. And this presentation was something we actually had been thinking about from the earliest days of the task force. We're looking into bystander training, but we realized that there are a lot of other groups out there doing it and doing a very effective job, such as Hollaback. They're very well known for their bystander training. What we noticed was missing, though, was a legal angle to it. And we, as a group of lawyers, of Asian lawyers, we thought we could provide value to the community by explaining some of the legal consequences and the legal implications of using self-defense, either for yourself or to help other people who may be attacked. And in this climate of anti-Asian violence, we thought that would be something that the community really should know, especially given all the reports about people carrying pepper spray and things of that nature. And we wanted people to know, what the consequences might be of actually pulling out that pepper spray and using it. And that, sometimes, the law can be somewhat complex, maybe a little bit murky, maybe sometimes not that straightforward. And we hope that this presentation will help to demystify that.
Okay, thank you, Young. So let's see, we have some other questions here. They're coming in. The next question. So I have seen news articles in retail e-stores that imply that having a stun device is permissible in New York City and can be purchased by mail. Can you clarify? So Joe, take it away.
All right, so I'm gonna share my screen again. I'm actually gonna pull the statute up. Give me 1 second. All right, can everyone see the screen? It's really small type. There's nothing I can do about that. Eugene, can you see it?
Yes.
Okay, all right. So the actual statute is Penal Law 265.01, and we call this sub 1. So this is the first sub, right? And you're guilty of criminal possession of a weapon in the 4th degree. That's a misdemeanor. If you possess, there's a whole long list here, and basically I read you some of the things on the list. But what you'll see right here is electronic stun gun, okay? So what's an electronic stun gun? Well, they actually also define all of the things that are listed there. So electronic stun gun is actually listed in a different section with a definition. And here's the definition. This is 265.00 sub 15-C. And it says electronic stun gun means any device designed primarily as a weapon, the purpose of which is to stun, cause mental disorientation, knock out, or paralyze a person by passing a high voltage electrical shock to a person. So where does that leave us? That leaves us at it's a prohibited weapon. Even if they're shipping it to you and selling it to you, I understand it's probably available on Amazon, but it is illegal. Some of you, I don't know how old you are, but you might even remember, I'm dating myself here, but back in the 90s, they used to have these magazines like Black Belt and Kung Fu Magazine. And in the back, you could actually open it up and look, and they would sell things like nunchucks, tonfa, shuriken, cane swords. All of these things were being sold, and you can actually find them online. You can buy them. But it would always say that, not available in New York. And the reason why is because it's a prohibited weapon here. And this was just statutes that they wrote. Some of them have been, challenged in court as violating the Second Amendment. But to my knowledge, these are still listed, with the exception of chuck-a-sticks and gravity knives. They're still listed as prohibited weapons. So the possession of an electronic stun gun, even if you don't use it, is a misdemeanor in New York.
Okay, Joe, so another question, I guess it's a follow-up to weapons, which seems very popular today. There's a question posed. It says, are toy versions of these per se weapons also illegal?
Well, for the purposes of this discussion, and remember, we're a group of lawyers here, I'm just going to say, don't own toy versions of these prohibited weapons. Because if a police officer sees you walking around with a plastic collapsible baton, you're going to get locked up. So whether they actually are or are not prohibited weapons, you're going to find out once you're arrested, and then you're talking to Eugene about your defenses to the criminal possession of a weapon case. So I just flatly going to tell you, don't do it. Just don't. There's a list there of things you can't possess. Anything that looks like one is going to get you locked up. So.
Yes. So don't do it if you don't want to get in trouble.
If you don't want to meet Eugene, don't do it.
Yes, yes. So next question we have here, since hate crimes are hard to prosecute, are aggressors or suspects not getting charged with this, I suppose, hate crimes, even if it's apparent that it's racially motivated?
So that's kind of outside of the scope of the self-defense discussion, but I am the chief of the hate crimes unit here in Nassau County. I don't want to do a mini CLE on hate crimes, but just to address your question, one of the factors in whether or not someone gets prosecuted as a hate crime requires that we prove that the motivation of the individual committing the crime was in substantial part based on race or ethnicity or religion, the whole list of prohibited, bigoted, protected sort of classes. So the way you prove that is by anything, right? So you can try to use any of the evidence at your disposal to prove those things. But just because you're strangers and of different races, that alone is not going to be sufficient to prove on itself that the person who committed the crime was substantially motivated by race. So I think that's where, you'll see sort of the facts of what happened. You'll see a video, you'll know this person was one race and the other person was a different race and they're strangers. Why else would they do that? And they're not being prosecuted as a hate crime. So I understand that there's this sense that, people it's too difficult. They're not doing it. Well, we need to show evidence. We need to show in a court of law beyond a reasonable doubt that this person was substantially motivated by race. And it has to be, the law actually says it has to be more than just the fact that you guys are of different races.
Eugene, may I add something?
Yes.
I want to offer this piece of information as more about what our task force is doing to address this problem. We agree with the questioner that there could be more vigorous enforcement of the hate crimes, but we also appreciate that if the evidence is not there, you can't prosecute. That being said, Albany's Anti-Asian Violence Task Force has set up a program called HEART, which stands for Hate Eradication Active Response Team. I'll drop a link to the webpage with more details. But the idea there is that we're going to have some volunteers from the Albany membership to serve as what we'll call navigators for survivors of these incidents, to navigate what admittedly is a complex system, because the legal criminal justice system is not at all straightforward. And we know that, since day one, when, these attacks were surging in 2020, all the government agencies, NYPD, DA's offices were telling our community to report, report, report. And I think what's missing in that is they don't really tell you how to report, what to report. They're not necessarily sensitive to the fact that we're dealing with a community that may not have English as its first language, that may also be coming from cultures that are not used to dealing with law enforcement, may want to shy away from getting into contact with law enforcement. So what we're hoping is that our volunteers through HEART will be able to work with survivors of these incidents and find ways to navigate the system. If they want help to report the incident, to put into a cogent story that NYPD and the various DA's offices will listen to and be able to work with, we can help do that. If they need us to point them to victim services or mental health services, or even private civil attorneys to see what kind of lawsuit they can bring to redress their injuries, that's what HEART is there for. So, I'm not suggesting that prosecuting the hate crime is necessarily the only way to deal with this. That's certainly one of the ways, but we certainly want the community to know about the HEART program. And if you know of people out there who have suffered these incidents, but have been too scared or just confused to come forward, please contact AABANY. We'll get a heart volunteer out to you, and I'll drop that information into the chat. And also, we've come up with Know Your Rights brochures in English and several Asian languages that will say in plain English, you know, what someone who encounters a bias incident or potential hate crime should do or can do. And it goes over just basically some of the differences between criminal and civil liability that was just touched upon here. So I'll drop that into the chat, but you know, we definitely would encourage community members to come and seek help from AABANY on this through our task force.
Thank you, Young.
Eugene, I just want to add just one extra thing on that subject of hate crimes and sort of how we go about proving that. Almost all of the advice that I gave at the end of this presentation regarding justification also applies to being the victim of a hate crime. So, for example, call 911 right away. Tell the 911 operator exactly what the person said while the crime was happening, like word for word, not something like exactly what the person said. And, you know, words matter. So if a person says, you know, COVID starter, and those are the exact words that he used, you want that to be documented somewhere as soon as possible. And the 911 call is a great place to do that. One issue that comes up later on is that you've retold the story 6 or 7 times, and now what exactly was said is kind of unclear. And if you can't say exactly what was said, that hurts my ability as a prosecutor to prove that the reason they did it was because of racial motive. We can't present evidence that he was saying racial slurs. That's not legal. I need you to say exactly what it was that you heard him say. And also, since people may not be native English speakers, you know when they're using the slur, right? Like, so you're gonna know when they're using a racial slur, like what that racial slur is. That's what you need to say, because that's another thing that'll happen is that when it comes time for trial, they'll say, you don't even speak English. How can you say my client said X, Y, or Z? So you saying that into the 911 call, like he was saying this while he was punching me, you know, that's important for us. Finding bystander witnesses that I mentioned, like that's important for us. Pointing out where the surveillance video is, that's important for us too, because by the time the police arrive, you may have moved, right? The action happened somewhere else, and now, you know, you're in a completely different place from where the assault occurred, and you need to let the police know so that they can try to go get those things. So almost all of the tips that I gave for you proving your justification defense also applies to helping prosecutors and police find a hate crime in these situations too.
Thank you, Joe. So to our next question here, the question asks, what can I do when I'm met with your ordinary street harassment or harassment on the subway without a physical threat? Would shouting at a close distance be viewed as potential physical force?
So again, this is all sort of fungible. The law I read to you is the law that's written. So it talks about what would a reasonable person think. Was there an imminent threat of physical injury? All of these things are, I mean, I gotta give all the credit in the world to Mr. Ang and Ms. Ching for translating what I'm saying, because these are very sort of, they're terms that are open to interpretation. So there's no, I can't give you a hard and fast rule for every situation what to do, except to say that when you're being harassed verbally, your best response really is to document it. I think it's much more powerful for you to take out your phone, create some distance, and start recording in case anything is to happen. Then I don't need your word. Like, this has been recorded. And as far as engaging with the other party, the only thing that's going to occur as a result of that is a potential escalation. And if they, you know, if witnesses on the street just hear 2 people yelling at each other and then a fight breaks out and you happen to get the better of the person who started this whole thing. Well, when the cops arrive, you're going to say what happened. Like, no, I never threatened him. He's going to say, like, look at me, I'm all beat up. I never threatened him. I don't know why he was hitting me. And both of you are going to have different stories. And all the witnesses are going to say, all I saw was two people yelling at each other and fighting. And then it's a he said, she said, which from the arrest standpoint, the police officers are going to arrest probably both of you. So I would ask that you keep in mind, like, look, if this is a situation that's definitely going to escalate to force, create distance, call 911, get some help, find safety. If it's absolutely necessary, at that point, you have to meet the force with the amount of force that's necessary to overcome the force that you're faced with. If you're looking to find situations where the other party's like threatening you, oh, I'm going to beat you up, and then you just punch him in the face, by the letter of the law, you might be able to argue that, look, this was self-defense, but you're going to have to be arguing that to your defense attorney to defend you in court because you're getting locked up. That whole process of proving your self-defense, even though it's not your burden to prove it, still the police officers are going to see this other person beat up, and the only person to strike him is going to be you. So even if by the letter of the law you're okay, proving that and getting to the point where you're okay is going to be very difficult.
Yeah, if I could just jump in here, because I think Karen asked such a great question. I think her question starts out by imagining scenarios that are strictly verbal without any threat of physicality, is how she kind of wrote it. And I think if a scenario of like verbal street harassment, as she puts it, where if you were to take a second and ask yourself, do I feel like someone that I'm about to get hurt? Do I feel like someone near me is about to get hurt? And if you kind of honestly answer that, no, this is a person who's just verbally ranting, and I actually don't feel like I'm in physical danger. Joe is basically saying that the law, if you were to strike that person, would find you guilty of a crime, right? Because the law of defense insists that there be the use of physical harm, physical force, or right, the threat of imminent physical force. So merely racist taunts onto themselves, I think, are not enough. But I think a little bit later, Karen was asking about, well, what if I'm being shouted at, right? At least this is how I understand the question. What if I'm being shouted at? Is that, could that ever be a time where you could use self-defense? And I think there, Karen's question just made me think about, well, it might depend what they're shouting. And as Joe said, they might be shouting like, I'm going to beat the crap out of you, right? They may also have been following you for the length of the subway car. They may also have just punched the person at the other end of the subway car. And so when you put all of that together, those words with that kind of extra evidence, you do feel like you're in physical danger, right? You honestly are now worried. If that's the case, then I think that you would be in a good place with this standard. Are you actually experiencing physical force, or do you feel like there's this threat of imminent force that's about to happen to you? And in that situation, if you were to strike the person, right, to protect your body, sure, you might still have to be arguing this and explaining this to your attorney, but you'd be on better ground. So I don't know. It's so hard in the moment to take a moment of calm, but I think, and I'm curious if Eugene would say any different as a defense attorney, but if you could ask yourself for just one quick second, and do I feel like I'm about to get hurt? It is a good, and I think most people have some common sense about that, have some reasonability about that. So
actually, that's a great point, Professor. Eugene, when you're defending someone accused of some type of assault, what's the first thing your client tells you?
I mean, it really just depends, I guess. But
how often are they asserting a self-defense type argument?
I would say pretty often, actually. They would say, yeah, self-defense, or there was like, either the other person was the initial aggressor, or they both just happened to get into like a verbal argument, and then all of a sudden it turned into a scuffle and they started fighting. but it's always kind of murky as to like who really started it.
And how many of those cases end up getting dismissed?
Not enough, but not enough if you ask me, but
it's work, right? Like, it's not just you show up and no, he threatened me and it's over, right? So like there is that whole thing. And the questions posed also bring up another point I want to make clear, this idea of the reasonable person. So for example, I believe it was raised, if somebody's yelling at you, let's say, even they were standing close to you yelling at you and you don't know what they're yelling and they're close and you actually feel afraid, like, I don't know this person, he's yelling at me, he's very close to me, and you take out your pepper spray and you just like spray him out. Well, you clearly were afraid. You were very afraid for yourself, but the standard isn't just that you're afraid. The standard's going to be, would a quote unquote normal person also have thought this person's about to use deadly physical force on me? So that's what the law of justification says. And it's often very difficult to get over that hurdle and to be in that sort of space. So your own personal beliefs are one part of whether or not you can be justified. But another part of who's justified is like, well, were you being overly sensitive, or was there something else going on with you? And really, those types of questions can come out in a lot of these situations. So you have to be cognizant of that as well, which is part of the reason why the justification defense is tricky.
That's true. Yeah, it is tricky. So we have another question here. I believe Young will answer. The question is, what, if any, reform to hate crime law do you think is possible or something to advocate for?
So,
actually,
yeah.
Young, do you want me to take
Everyone
it?
can jump
Yes.
right in.
Yeah, that'd be great. Thank you.
Great. So this is a question that really allows us to talk about another project that the task force has been working on. And it kind of goes towards the question that Joe was handling earlier, which is, which of these many incidents that we are seeing in the press are actually being prosecuted as hate crimes. And Joe was really great to kind of explain a part of the New York State statute and just how hard it is to find enough proof beyond a reasonable doubt. And so one of the projects that the task force is doing, and these will be shared with the public, I think, in future reports, is to try to understand, which incidents are making it past those proof barriers, which incidents are not, and why that might be the case. What patterns, what might we be seeing in Nassau County or Richmond County, or let's say Manhattan County. And so we are definitely thinking about whether or not some of the barriers are coming from the statute themselves. And I will say, for instance, that section that Joe talked about, in whole or in substantial part, that these are racially motivated acts, is a part that may be ripe for change. We're going to look at what some other state statutes may have, and I'm pretty sure, without having completed the research, that some other state statutes don't have that phrase, in whole or in substantial part, and simply will say that a crime that's committed because of a belief about a race, because of, is like their only kind of connective element there. And so it may be that the New York statute is ripe for some change. The other thing I'll say that we are thinking might be produced by our research is that we may notice a pattern where the barrier, so to speak, to hate crime prosecutions may not really just simply be the statute, but may instead also be, and this is something we're looking at, beginning to look at closely, is really how the DAs are really training their people, how the DAs are emphasizing or making this a part of their agenda, how the DAs frankly are hiring and promoting diverse attorneys into their positions, their entry-level positions, as well as their senior positions. And so we're going to take a really comprehensive look at that and think about reform.
Okay. Yeah, Young, I don't know if you want to add anything. If not, we can go on to one of the other questions that we have.
Nothing to add there. Elaine did a great job. Thank you, Elaine.
Let's see. Can spitting be considered use of force, particularly in the midst of a pandemic?
I'm going to say a bright line. No, it's the reasonable person standard is going to be your big barrier there. You may think it's particularly disgusting. You may also, think that it's potentially endangering you. Generally speaking, those things are possible. There are certain types of cases involving, for example, HIV positive people who are, throwing their blood. So there are certain scenarios in which that fact pattern has come up, but the scenario you're describing is some stranger spitting on you during the pandemic. If they did it because of a belief about your race, if they said go back to China, something like that, that's actually a misdemeanor, which you should be getting them arrested for. That is not a reason to start fighting them. So if you were in that scenario and that was all on video, that is something certainly a prosecutor would consider in terms of how they handled the case, but you would not be able to say that you were justified, right? Because you're only justified in using the necessary physical force to meet the physical force. And in that scenario, you've been spit on. And that's pretty much it. So I would just say if someone spits on you, again, get your phone out, tag them, shame them. That's really the most effective thing that you can do. And quite frankly, when there has been videos of people doing things like that, they've been extremely effective at, causing that person to have to apologize, losing jobs. It's a tremendously effective way of dealing with these types of slights. And also that's the evidence that you then go back and you show to the police officers so that that person can be arrested for aggravated harassment in the second degree, penal law section 240-30 sub 3. It's a statute that makes spitting on people on the basis of their race illegal.
Okay, so one last question we have before we wrap this up for tonight. We don't want to hold everyone here too long. The last question, it's from Christopher Chen from the Coalition of Asian Pacific Americans. And he wrote, "Thank you, AABANY, Joe, Elaine, and Eugene for hosting and making this information available to our community. I'd also like to ask, what considerations might martial artists need to be more conscious of in self-defense and prosecution of others?"
I love this question. I also want to note, so I'm the co-chair of the prosecutors committee of AABANY, and our other co-chair, David Chang, is a martial artist himself. I believe the Wu-Tang of New York school. So shout outs obviously to him. And that's part of the reason why we're here today to talk about some of these issues, is that if you are a trained martial artist and you're faced with these scenarios, like you want to make sure that you're not going to be on the wrong side of the law. So I think one thing you have to be very conscious of is, and this is just off the top of my head, the whole concept of necessary physical force. If you're, ground and pounding the guy after he starts hitting you, that's going to be a problem. You have to meet the force and use the force necessary to overcome the physical threat, whatever that may be. And the amount of damage you do to the other person can end up, causing a problem for you. And also, you have to be conscious of the fact that, you probably are going to be able to do a lot more damage to the other person than he will to you. He or her will be able to you. So that's also something you have to consider, because if you end up using an arm lock or, some other type of move that really ends up, breaking an arm or causing what might be serious physical injury, even if you are justified under the letter of the law, as we talked about it today, you still are going to have a problem, because the police are going to arrive and the other person's going to look like a pretzel, and you're going to be perfectly fine, which means, you know, in that scenario, you're probably the only person that's getting locked up. And it's going to have to go through that whole process of you sort of explaining what happened and more or less having to prove what happened. So I think my main point here is that I guess the same point that, you know, martial artists teach that first lesson to the young children: use only if necessary and only to the extent that you have to. And be conscious of the fact that your trained ability could be used to make your actions seem more unreasonable than otherwise. So, you know, use restraint would be my advice.
Okay, so I guess that wraps up all of our questions. You know, at this time, I want to acknowledge and thank our co-sponsors for today's webinar: the Coalition of Asian Pacific Americans, Asians in the Americas Association, the Association of Law Secretaries to the Justices of the Supreme and Surrogates Courts in the City of New York. And of course, a thank you to you know, our wonderful interpreters, Kwok and Ye, our speakers, Professor Chu and Joe Kim. And then also a thank you to Young Chen and Francis Chin for having everything run smoothly here tonight.
And thanks to Candace. She's always making sure this thing runs. She's the best.
Yeah, thank you, Candace. We're going to miss you. All right. Well, thanks everybody for joining us. We hope you have a pleasant evening, and please stay cool. Good night.